Good afternoon, financial professionals. Abby Fletcher here of E4 Insurance Services, welcoming you to The Brew, building relationships every week. Thanks for tuning in today. For those of you joining The Brew for the first time, we like to start the Brewcast by celebrating today's National Day for May 5th. Today is Cinco de Mayo, otherwise known as the 5th of May. And while many of us, self-included, think of today as Margarita Day, we are actually celebrating the Mexican Army's unlikely victory over the French forces of Napoleon III on May 5th, 1862, otherwise known as the Battle of Puebla. We celebrate this victory with Mexican products and services with an emphasis on food, beverage, and music. So today, crank up your mariachi music and raise your favorite salt-rimmed glass to the annual celebration of Mexico's victory. Today on The Brew, as part of our industry update series, we have Linas Sudzius, who serves as president of Advanced Underwriting Consultants. Linas holds his JD, his CLU, and his CHFC, and is also a published author. Today, Linas will be sharing more details regarding the recent update to the IRS Publication 590B. And while this happens to be a very fluid topic, we are eager to have Linas on the show to shed some light in the background and what to be prepared for. Feel free to use the chat box below while Linas is live. I'll be keeping a lookout for your questions. Also, all attendees are in a drawing for a prize, and we'll be announcing the winner shortly. Thank you for tuning in. And without further ado, Linas, welcome. The mic is yours.
Abby, thank you so much. Thank you for allowing me to be part of your meeting here today. I want to talk today about Publication 590B and the IRS's recent update to Publication 590B, which surprised a lot of us who are in the financial services business. You know, it's even though Publication 590B is not an official publication, you know, we do look to it for guidance from the service, and the service definitely did surprise us. So let's talk about what the surprise is and what you know, what we might ought to do going forward. So first of all, we have to start with what we thought we knew about the Secure Act and the new stretch rules. So the Secure Act changed the way that stretch worked for inherited qualified accounts for those accounts that were inherited because of a death in 2020 or later. The Secure Act created, you know, all kinds of new different categories of IRA or qualified plan beneficiaries and new rules with regard to when minimum distributions had to be taken. The rules didn't change hardly at all for surviving spouses. Surviving spouses tend to have the same stretch choices they had before the Secure Act, namely that the spouse could stretch based on life expectancy if they chose to treat the account as inherited, or could put the inherited account into their own IRA and treat it as their own from that point forward. Nothing about that has really changed. But different non-spouse beneficiaries have different choices. Some, if they're the children of the account owner, for example, still get to stretch for a while based on their life expectancy. But most non-spouse beneficiaries, including adult children of the account owner, have a limited time to liquidate the account, namely 10 years. 10 years to liquidate the account. And of course, the income tax result gets associated with the timing of the liquidation. If you got to liquidate the account sooner under the Secure Act than you did under the old rules, you have to pay income tax sooner than under the old rules. And so that's part of the reason, I suppose, that the federal government thought the change was in order. So in any event, most non-spouse beneficiaries are stuck with 10-year liquidation on an inherited qualified account. But one of the key things that we thought we knew, based on the language in the Secure Act itself, is that if we had a non-spouse beneficiary of an inherited IRA, that while the beneficiary has to liquidate the account on or before the end of the 10th year after the owner's death, there were no RMDs that were due along the way. Now, the language of the Secure Act is kind of meandering and kind of confusing, but it seemed clear that based on the actual language that was in there, that no minimum distributions were needed along the way. So we've got 10-year liquidation, accelerating the ultimate disposition of the account for non-spouse beneficiaries quicker than under the old rules. But one of the advantages over at least some of the old rules is that there were no RMD obligations along the way, or so we thought. Then came IRS Publication 590B, which was published a few weeks ago. And it's still, the version that's troubling is still online. Now, 590B is not an official pronouncement of the IRS. It doesn't rise to the level of a revenue ruling or even an IRS notice. It is simply something that is published online as a guide to taxpayers. It is still online. The problem is that so many people rely on what the IRS has published in Publication 590B that it still has the potential to mislead people. There's one example of this in the past, and that is the IRS in the past had something online about 60-day rollovers, which taxpayer relied on and did multiple rollovers from one IRA to another in a year in reliance on the words that were there in Publication 590, the predecessor to 590B. And the IRS decided that it was going to fight that taxpayer and say that you're only allowed one 60-day rollover from IRA to IRA in a year, despite what Publication 590B said. And it was a big mess. Tax court decided in favor of the IRS, and it ended up being a disaster. And so the IRS cleaned up what it said in Publication 590. It created Publication 590A and 590B, and also came out with some clarifying notice as a result of that Bowbrow case. And so, the IRS getting it wrong in the publication does have a history, and it can be a disaster for taxpayers. So what does 590B actually say that is troubling? Well, in particular, an example that it gives for a non-spouse beneficiary is reproduced here on your slide. You've got dad that dies in 2020. So dad's IRA is subject to the Secure Act rules. Got adult child as the beneficiary, and the example goes on to say that the adult son who is the beneficiary has to take RMDs based on his life expectancy in 2021 using the table method, which is what we used before the Secure Act. And it implies that the surviving son has to take RMDs every year along the way, in addition to having to liquidate the inherited IRA by the end of the 10th year after dad's death. And that's the surprise, right? The whole language there about using Table 1 to calculate RMDs is something that's a brand new idea for those of us who have studied the Secure Act. And it was interesting that the IRS decided to include that language in Publication 590B. And what's the explanation for what the IRS put in there? Does the IRS have a different interpretation from the rest of us? Or was the IRS just sloppy in how it edited Publication 590B to be consistent with the Secure Act? Well, we weren't really sure. And the experts in our field seem to be pretty sure that the IRS had made a mistake. Slot, for example, said, hey, the IRS surprised everybody. 10-year in saying that the 10-year rule requires RMDs along the way and the account to be liquidated at the end of the 10th year. So Ed read the example the same way that we're reading it today, seems to require RMDs along the way in additional liquidation at the end of the 10th year, which, by the way, I've heard anecdotally a few carriers have also interpreted the rules that way, that RMDs are required along the way with liquidation at the end of the 10th year, even though most experts seem to think that RMDs are not required, despite what the IRS said. Natalie Choate, many of us recognize her. She was a little more straightforward about it. She said what's published in publication 590B is not consistent with how the 10-year rule works. It's not consistent with the language of the Secure Act. Natalie has insisted that no RMDs are required until the final year at the end of the 10th year for a non-spouse beneficiary. So in light of that uncertainty, with the inconsistency between the IRS and the experts, what do we do now? The answer is, well, I think we have to think about talking to our non-spouse beneficiary who inherited qualified accounts, including inherited IRAs in 2020 or later. I think it makes sense to tell them or warn them that they might have to take an RMD this year, particularly if we've told them differently or indicated differently to them before. But I don't think anybody needs to be in a hurry to actually take RMDs. I think waiting makes all the sense in the world. That the IRS may in fact come out with something new, some kind of correction before the end of the year. And so I think waiting is prudent. If the client does not need to take money out of the inherited account, then the client should wait to take the RMD. If the client, doesn't want to increase their taxable income this year. The IRS might publish something later this year. If that does happen, we'll be in a position to tell the beneficiaries in more detail what the IRS really thinks. We don't have to rely on an unofficial publication. But if the IRS doesn't come out with anything new, well, we might tell our clients that they need to take RMDs before the end of the year. And just to make matters even more interesting, a day or two before I finalized this presentation, there was an update that appeared online. It now appears that the IRS agrees that the examples in publication 590B are incorrect. MarketWatch, which you can find online, has reported that the agency plans to revise publication 590B to reflect the correct information, which is that beneficiaries have 10 years to withdraw the money in whatever fashion they would like. Now, this is even less official than publication 590B. This is quoting an unnamed source within the service, but it is encouraging that this report has existed. And we're hopeful that 590B gets corrected. And we're also hopeful that some of the other ambiguities that are associated with the Secure Act are also addressed. Things like, can we rely on look-through trust rules? How will they apply to certain circumstances where we've got minor beneficiaries as one of the trust beneficiaries? Is there any flexibility on how RMDs are taken under those circumstances? Those are questions that were not specifically addressed by the Secure Act. They need to be addressed, and we're hopeful that we get some clarifying regulations or other clarifying publication from the IRS before the end of the year, including confirming that no RMDs are due from regular non-spouse beneficiaries who have to liquidate by the end of the 10th year. So this is us. If you've got questions for us, feel welcome to email at asktheexpert@advancedunderwriting.com. And at this point, what I will do is I will shut up and ask Abby if there are any questions that I can answer.
Thanks, Linas. Great content.
Thank you.
I've got one coming in right now, but you've sort of answered it. And also for the audience, now would be the time to either unmute yourself or send me a quick chat on your question. So Linas, you briefly touched on this, that there are going to be some revisions or clarifications to this publication, but will you give us your first look thoughts on this question? We had an advisor write, if an IRA owner passes away and leaves the funds to a minor, how does this affect the minimum distribution rules? More specifically, does the assigned custodian have to begin required RMDs on behalf of the child within 1 year of death? Does the 10-year clock for full account redemption start now or at age of majority, 18, and go through age 28, etc.? What are your thoughts?
No, it's a great question. Here's how we think it works. While the minor is young, whoever is acting on the minor's behalf takes RMDs based on and by the way, this is only available if this is a minor child of the account owner.
Got it.
Right? So if it's a minor child of the account owner, RMDs are taken along the way while the child remains a minor. And we think that that means minor is defined under state law. So if the age of majority is 18 in the particular jurisdiction, the minor stretches based on the minor's life expectancy, beginning with the year after the account owner's death, takes RMDs for each one of those years until the minor reaches age 18, at which point the 10-year clock starts. Mm-hmm. And so, you know, the minor doesn't have to take, or the minor who's now a major, right, does not have to take RMDs for the next 10 years, simply has to liquidate the account by the end of the 10th year after death. That's how we think it works. Be nice to have some regulations that spell that out, but that's how we think it works based on the language of the Secure Act. Got it.
Thank you. Any other questions from the audience? I see a comment from Brendan. I'm just going to read it. This all sounds like a good reason to not be in business with the IRS. No idea when we'll be forced to take income and what the tax rate will be. So very relatable comment.
Brendan makes a good point. That's one that's worth making out loud, I think. And that is that for those of us who are in and around the life insurance business, using life insurance to cover the income tax exposure associated with account liquidation is something we ought to be talking to our clients about, right? Because this tax that the beneficiaries have to pay, and the income tax, is really unavoidable. And so, and it's going to happen sooner for most of them than they might have planned for under different circumstances. And so they ought to think about, the parents ought to think about providing life insurance, which is income tax free, of course, to help them pay the tax when the time comes.
Well said, Linas. Any other questions from the audience? I'm going to take that as a no, and please join Linas's YouTube channel and check us out on the Brew blog. This presentation will be recorded. Time for the drawing, Linas. I'm going to ask you to choose a number between 1 and 32.
Let's go 32.
32 it is. Who's the winner? Okay, Charles Chorus, congrats. Be on the lookout for a coffee card and complimentary CE coming your way from all of us here at E4 Insurance Services. And be sure to tune in next Wednesday. We will have Andrew Herrera of North American on the Brew discussing insurance opportunities for 2021. And he'll also be touching on 7702, so you don't want to miss this one. Thanks, friends. Make it a great day.